Welcome back. I'm attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today's video is going to be a little different. We're going to do some pretending where you're going to be a client coming into my office for the first time, and I'm going to explain what a revocable living trust is the same way I do if we were to actually meet in person. Oftentimes in this situation, clients are coming in with very little background in what they may have heard in terms of a living trust, probate, last will, living will, powers of attorney, and so on. But they typically don't know what each document is and how they work together. With that, you can use this as an example of what meeting an estate planning attorney should be like, or as part of your research into whether a living trust is right for you. Without further ado, let's dive in. Now keep in mind, every meeting is going to be different as people have different questions, different goals for their estate plan, or simply different assets to plan around. So not everything I talked about today is going to be applicable for every person. You can think of your estate planning as a fingerprint. Everyone has one in some fashion, and each is unique even if the overall structure is similar. For instance, one house and two bank accounts. To begin, there are generally two goals with estate planning. First is to direct where all our stuff goes after we pass away, and we do that through a writing, either it be through a will or a trust. Either one of those can make the directions, but they get a little bit different when we take into account the next goal, which the next goal is to maximize what actually makes its way down to where we want it to go. And by that, I just mean to kind of mitigate or outright avoid a lot of the fees, costs, legal headaches that come along with administering someone's estate after they've passed away. By this, I'm generally talking about probate and avoiding probate entirely. So probate court is essentially a judge giving a live person authority to manage somebody's assets because we consider the assets so important, we need to make sure that someone has authority to manage it in the first place. So in essence, you're it. You can sign title changes on the real estate or go and collect certain bank accounts. Now the reason we want to avoid probate is because it's very expensive, time-consuming, and a big headache. Probate, just to get through the system, costs about $1,500 to $2,000 and sometimes even more. It can take 9 to 12 months, or the second there's any type of slight road bump or hiccup, we're in there for another 2-3 months at a time added on top of that. Additionally, attorney fees are set by the California Probate Code, so no matter what attorney you go to, they're going to get the same fee, and it's based on the gross value of what passes through the estate, not the net, meaning that every attorney is going to get paid a pretty big chunk of money. In essence, the attorney is actually the one that gets all the money, not necessarily the state. And that fee is, like I said, based on a formula in the probate code. Let's say we have a $500,000 estate. The attorney fee is going to be around $13,000 or so. If we get close to $1 million, then the attorney fee is going to jump all the way up to $24,000, and it just keeps going up from there. So let's avoid the probate entirely. Let's avoid paying all those hefty fees, and instead we create the living trust, hold our assets in there, and avoid the probate entirely. So how does the trust work? Well, in the trust, there's 3 roles that you're going to play. You're creating the trust, so you are the trustor. You're the one who sets up the trust, controls the terms in the trust, and the only person with authority to make changes to the trust or even revoke it entirely if you felt like it. Next is the trustee of the trust. The trustee is the manager of what actually makes its way into said trust. What that means is that the trustee is the one who signs the paperwork for title changes on things like real estate or bank accounts. They're the ones writing the checks. And third is the beneficiary. So you're also going to be the beneficiary in this situation. The beneficiary is the one who benefits from what's in the trust. So with that, the trust has the trustor, the person who creates the trust, that's you, and the person who controls the terms of the trust. Next, we have the trustee. That's also going to be you. The trustee is the one who manages the assets that are actually in said trust, and the trustee has to manage those assets for the benefit of the beneficiary, which, number 3, beneficiary is you. So you control the trust, you manage what's in there, and you get to benefit from everything that's in there. In essence, what that means is that the trust is you, it's all your stuff, and you get to do whatever you want with your stuff. By getting to do what you want with your stuff, I mean you can do everything you normally can do. You can buy real estate, you can sell real estate, you can buy stocks, you can invest money, or you can blow it all on a wonderful European vacation. It's all your stuff and you do what you want with it. Going further, no one even cares you have a trust. The IRS and the Franchise Tax Board for California don't care you have a trust. It's what's called a disregarded entity. So the trust does have a trust identification number, but it's just your social security number. Next, it also won't change your property taxes. So yes, your real estate is going to get transferred into the name of your trust, but here in California, transferring real estate to and from a revocable living trust is an exempt transaction for real property, thus no reassessment of the property. That just means your property taxes are going to stay the same once you transfer your house into the trust. At that point, the trust owns the property, but again, it's your property, you manage it, and you benefit from it. So again, your stuff. The same principles apply for bank accounts. Any money you have in a bank account under the name of the trust is still going to have your name on the account just as the trustee of the trust, and it will have the trust name on the account as well. But otherwise, you can write checks out of the account as normal and just use it to run your monthly bills as normal. Or you can have it sit there and collect money over time and just grow your overall estate. Now, to make it clear, the way the trust avoids probate is because we always have a live person that can manage the assets that are owned by the trust. So think about it this way. I'm here, the trust is me, so after I pass away, I'm dead on the ground, but the trust actually continues on standing in my position, owning all the assets, but a new manager steps into the side and can now manage the property. Like I said before, signing title changes and just managing what's there, so now we don't have to go to a court to get a judge's approval and grant somebody authority to manage things. When determining what actually goes into the trust, we just have to keep two things in mind. The two probate threshold triggers. First is real property regardless of the value. Triggers a probate, so we take all real estate regardless of the value, throw it into the trust, even if it's real estate in another state. It's going to trigger a probate over there, so throw it into your California trust. Next is a total estate value of $184,500 or more, which is kind of a random number, but it's tied to inflation. And it gets adjusted every 3 years here in California, but be careful, that number is state specific. So if you're in Nevada, that number is going to be $150,000, and it's just going to stay at that number. But again, here in California, it's tied to inflation, adjusted every 3 years, so it will adjust over time. Now, how do we get to that number? So it technically means all your assets. So your money in the bank, your personal items, your car, just different things all kind of thrown together in one big lump. And you can actually kind of think about it this way. You're essentially building a meter, getting to $184,500. Once your estate is at or above that number, well, we're now in danger of triggering a probate. So the way we lower that number is we take chunks of money out of that and we throw it into the trust over there, where the value doesn't matter, not going to trigger a probate. So we're building that meter, but we take chunks of money out and we throw it into the trust, and it allows us to drop that meter down. Now the trust is holding our money, it can grow in there to whatever number, and we never have to worry about a probate. When it comes to what bank accounts and whatnot to actually put into the trust from the get-go, it's going to be very situation dependent, but generally a good rule of thumb is if an account has about $50,000 or more in it, then at that point, it's worth taking the time to retitle that account from your name as an individual to your name as trustee of the trust. Next, you're still going to get a will with your trust. And at the top, it's going to say last will and testament. But when we look at the distributive provision of the will, instead of having your distribution laid out, it's actually going to say everything in my estate is to pour over into my trust. So it's a pour over will. And what that is, it allows your successor trustee, the person who steps in, manages all your stuff after you pass away, to go and collect everything and put it into the trust so that it can be distributed to the beneficiaries in the way that you designated when you first created the trust. And at that point, because you've now passed away, the trustors are no longer there to make changes to the trust. The trustee just has to follow what the trust says. They can't make any changes or adjustments. And at that point, it's going to be collect all the trust assets, pay off any last debts and expenses, and distribute things out to the beneficiaries how you laid it out when you set up the trust initially. Lastly, in our office, you get a few more documents with your trust and your will, one of which is a certification of trust. It's kind of a summary of the trust terms, but it takes all the legalese out, and it's a document you can give to a third party like a bank or an escrow company, and it tells them just some pertinent details about the trust and, most importantly, how to title assets into the trust, so you don't have to come back to the lawyer to make an amendment just to add an asset to the trust. Next, you would also get a financial power of attorney and an advanced healthcare directive, or the healthcare power of attorney. Now these two documents are effective during your lifetime, but after you pass away, the trust takes over everything. But these documents, they cover what you'd expect: Financial power of attorney covers financial matters and is primarily there as a way to allow family to step in and assist with managing your finances if you get to the point where you're either incompetent or just unable to manage your finances. And the Advanced Healthcare Directive allows somebody to help make medical decisions if you are also incompetent or just unable to manage your own healthcare situation. Additionally, our office would also create new grant deeds in order to retitle your real property into the name of the trust. Like I said before, it is a transfer from you as an individual to you as trustee of your trust, but that transfer will not cause a reassessment here in California because it's an exempt transaction. At the end of the day, the only thing that does change is that it should have comma trustee behind your name on your property tax bill. Otherwise, that's it. Finally, there's a few more documents that we would typically give you with your trust documents, but a lot of that is going to depend upon your particular situation and what assets you actually have in your estate. If you have any questions on this or any other topics, then please drop a comment below and I'll do my best to cover them in future videos. Don't forget to like this video if you found it helpful and subscribe to our channel for more easy to understand insights into estate planning, finances, real estate, and taxes. Watch our last video here or check out this other great video.